AKE.
Can we spell it, my lord? EKEAN.
Hello.
Yes, my lord.
Okay. You were giving the link of your son name, Ebuka, AKE.
EKEAN. YAN. WU.
Okay.
My lord, my appearance is for the claimant.
Defense counsel.
May it please, my lord. IW. Egat Olushesi. Egat is spelled EGERT. RT. Hyphen Olushesi is spelled OLU.
Yes.
SESI.
Yes. Okay.
But I appear for the defendant.
Okay.
Appearing with me, my okay.
Go ahead.
Appearing with me, my lord. EY. Ajayi.
Okay.
And FT, my lord. Antro is spelled AN.
Yes.
ANCHUR, my lord.
CHUR. Okay. Okay.
My lord, we appear for the defendants. Yes, my lord.
Okay. Today we have judgment, and the judgment is written by Honorable Justice Agbakoba. I'm going to read the judgment on her behalf because she cannot be equipped this afternoon.
Have a call, please.
So goes ahead with the judgment. The claimant at the beginning commenced the action here, the general form of statement of fact, and other formulated processes dated and filed 5th November 2019. Commenced this suit against the defendant. However, by an order of the court, the claimant filed and served this amended general form of complaint, statement of fact, and other processes outdated
filed 7 December 2020.
And filed 7 December 2020, seeking Honorable Court for the following reliefs. A declaration that the dismissal of the claimant by the defendant by the first defendant's later dated August 2019 and served for the claimant in August 2019 is wrong, unlawful, null and void, and therefore a breach of the claimant's right to fair hearing protected under Section 36(1) of the 1999 Constitution of the Federal Republic of Nigeria as amended. Chapter 3, Section 3, paragraphs 00304, 030303, 030307, and Section 4, paragraph 030403 of the Federal Public Service Rules of Nigeria. Another setting aside the dismissal notice dated the 15th August 2019, issued by the defendant, but served on the claimant on the 15th of August 2019 for being unlawful, null and void, and the breach of the claimant's right to fair hearing protected under Section 36, sub 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended. Chapter 3, Section 3, and Section 4 of the Federal Public Service Rules of Nigeria. Another directing and compelling the defendants to reinstate the claimant and accordingly pay the claimant all her outstanding salaries, benefits, and other entitlements that are and or will become due from June 2019 to the date of the claimant's reinstatement. And other directing and compelling the defendants, either by themselves, officers, staff, or however described, to allow the claimant for all her promotion examinations due to her at present, or which may become due to her before or after the date of the claimant's restatement for the purpose of promoting the claimant to the next week. And other directing the defendants to pay the claimant the sum of 50 million naira only as general and exemplary damages committant to the defendant's wrongful act of publishing the claimant's name as an erring officer dismissed for serious misconduct on its official notice board, thereby maligning the claimant's character and good conduct and causing severe damages to the claimant's reputation and character in the labor force. The sum of 1 million naira only being the unwarranted cost of instituting and prosecuting this suit against the defendant. In response to these two comments, the defendant first filed its statement of defense and all front-loaded documents, which were initially out of time on the 23rd January 2020. However, the defendant subsequently filed an application to amend its amended statement of defense on the 1st of December 2021. The defendant's applications were, and an order of court, the defendant's amendment of defense and other processes filed on the 1st of December 2021 was deemed properly filed on Thursday. The claimant filed in the of law on the 18th of June 2021. Before proceeding, give a brief summary of the claims and the defense of the defendants to the claims. The claimant's case. The crux of the claimant's case is that until her wrong dismissal, she was employed in service of as a senior superintendent legal officer on grade level 12, and her appointment was confirmed by the letter of a confirmation of appointment dated the 14th September 2009. The claimant averred that the defendant, on account of his decision via its official email address on the 15th of August 2019, unjustifiably and wrongfully issued her a notice of dismissal dated the 9th day of August 2019. She averred that the dismissal notice was equal to a unilateral disciplinary procedure by the board of the defendants, which allegedly held that the claimant proceeded on leave without prior permission or approval by the first defendant, despite evidence to the contrary confirming conveying the first defendant approval of the claimant's annual leave. The claimant averred that in disregard of the Federal Public Service Rules of Nigeria, failed to notify her the statutory notice plus invitation to formally appear before the first defendant's disciplinary panel and accordingly denied her the right to be fairly present a defense in line with the Federal Republic of Nigeria and Section 36 of 1 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and the defendant's wrongful dismissal notice was also issued to the claimant 2 months late after prior of the claimant's voluntary retirement on the 17th day of June 2019 and the 4th day of July 2018. The defendant's defendant, on the other hand, that the claimant also being in the habit of being absent from duty. Also, before the claimant proceeded on her annual leave in 2019, there was already a preliminary action against the claimant by the first defendant for absence from duty without leave for a period of months. Defendants averred that the query and a pending disciplinary action against the claimant. Claimant was banned from sitting for the promotion examination in 2018. Despite the failure of the claimant to appear before the board subcommittee on staff welfare and disciplinary matters in June 2019, he ought to have resumed annual leave since 30th day of 2019. The first defendant issued invitation to the claimant on June 2019, previously dated 10th May 2019, for the claimant to appear before the board of staff welfare and disciplinary matters on the 11th day of June 2019. Still, the claimant failed to refuse the invitation of the first defendant. Defendants averred that the claimant was duly notified of these invitations from one layering to follow via a work message on the 10th June 2019, but the response of the claimant to the message, amongst other responses, was that she was not back yet. The invitations above were brought to the claimant's unit of the defendant at the time because it was deemed that the claimant ought to have resumed from leave as at 30th May 2019 as ought to be served on her at the duty post. That the claimant voluntarily proceeded on a supposed casual leave and extended 1 leave without any prior approval by the first defendant, and the claimant traveled out of the country for her annual leave without informing the defendants, and did not report to her duty post at the expiration of a 2019 annual leave, of which the claimant has a duty under Chapter 10, Section 2, 100206 of the Public Service Rules 208 to inform the defendant that she will spend a leave outside the country, which the claimant failed to do. And by virtue of the Public Service Rules, the claimant who failed to resume duty after the expiration of the leave was regarded as absent without leave and hence without pay. The defendant further averred that despite absenting herself from her duty post for a period over 30 days after the expiration of her annual leave in 2019, the claimant was directed in federal memo dated 2nd June 2019 to report back to her duty post immediately, but she failed to comply with the directive. Instead of reviewing both a letter of note of voluntary retirement received by the defendant on the 4th day of July 2019. By virtue of the notice of retirement of the claimant, which the defendant received on the 4th day of July 2019, the claimant stated that the retirement was to take effect from the 4th July 2019. The claimant report and due procedure in the notice of retirement and not giving the 3 months notice the intention to retire while duty as provided for in Chapter 2, Section 2, 100228 Public Service Rules 2008 edition. The defendants finally averred that the board subcommittee of welfare and crime matter recommendation in the disciplinary action by the claimant came to the conclusion that the conduct of the claimant amounted to serious misconduct and an act unbecoming of a public officer, and so the claimant was deemed to have deserted her duty and hence resumed and hence recommended a dismissal of the claimant for service of the first defendant. At the trial, which commenced on the 29th day of September 2021, the claimant testified for PW1 and as the sole witness. She adopted a written statement oath filed on September 2020, which was then admitted in evidence as Exhibit C1. The witness also tendered the following documents. Exhibit C2 to Exhibit 54 and document the claimant's witness was cross-examined and discharged. The claimant did not re-examine her witness. The defendant's 21st day of July 2020 entered 4-day witnessing. Senior testified as DW1. Omore testified as DW2. Mr. S.O. Igudu, a senior witness. It was brought to the notice of the court that two witnesses, one Arocha Peace and Mr. Olubukola Balon, by way of the subpoena ducus tectum and testified failed to present in court. Let's tender the following exhibit. Exhibit 1 to exhibit 19. The details are in the court judgment. Defendants' witnesses were examined and discharged. Defendants did not regulate. The court adjourned for adoption of final written addresses. Filed the final written address initially out of time, but they prayed and ordered for extension of time. They didn't wish to file their final written address. The court granted the prayer. Secondly, deemed the final written address as properly filed and served on the 27th day of 2020. Final written address on the 31st day of May 2023. The claimant, however, prayed the court to exceed the 35 pages final address provided by Rule 17 by Order 17, Rule 1 of the Civil Procedure Rules of this court. The prayer was granted. Defendants filed their reply on point law on the 16th day of June 2023. In the judgment, we have the defendant's house of submission. All the evidence in the judgment. I'm not going to read all that. I'll go straight to the court's resolution. Carefully summarized case before the court, and having carefully reviewed all the authorities cited through, suggested the contention of the parties. Their written submissions are herewith incorporated in this judgment, and specific mention will be made to them where the need arises. I shall now proceed to deal with the merits of the case, seeing as the claimant and the defendant argued their respective positions under the same issues. These issues shall be the issues for determination of dispute, to which meaning whether having regard to the totality of pleadings, evidence clear, and particularly the provisions of the public service rule and the guidelines for appointment, promotions, and discipline issued by the Federal Civil Service Commission, it could be rightly said that the claimant was unlawfully and wrongfully dismissed from the service. So, considering the totality of pleadings and evidence adduced in this case, whether the claimant is entitled to the relief sought against the defendant. 3. The defendant's dismissal by the first defendant was wrongful, unlawful, null and void, and in breach of the claimant's right to fair hearing. 4. The claimant is entitled to other relief against the first defendant. The crux of the case is whether the dismissal of the claimant by the defendant by the first defendant's letter dated in August 2019 was lawful, whereas the claimant has submitted a notice of voluntary retirement dated 17th of June 2019, which the defendant acknowledged receipt on the 4th day of July 2019, as contained in paragraph 6 of the defendant's statement of defense. The defendant advised the claimant did not follow the proper and due procedure in a notice of retirement letter by not following the procedure provided with 100238 of the Public Service Rules 208 edition. Please note that the court was not able to assess the authority, as either it was wrongly cited or simply does not exist. The defendant further avers that having not complied with this requirement in a notice for retirement, the claimant retirement notice was not accepted for the first defendant. The basic law by Governor Edo State is that the notice of resignation in appointment comes to be valid the moment it is received by the person or to whom it is addressed. This is because there is absolute power to resign, no decision to refuse to act, and it is not necessary for the person to whom notice of resignation is to reply that the resignation is accepted. It is not in doubt that the defendants received in 615 the resignation later on the 4th day of June 2019, the date the letter itself was written by the claimant. The resignation of the from the 20th day of June 2020, that is immediate effect as the claimant desired. What is the legal effect with immediate effect of the claimant did in the instant? In versus provided, the notice of resignation is effective not from the date of the letter, from the date of acceptance, but from the date on which the paper was received by the employer or his agent. And the tendering of a letter of resignation by an employee carries with it the right to leave the service automatically without any benefit, subject to paying any of his expenses to his employer. And by Ubu and NEPA, the CRO provided termination of the contract, either giving a particular length of notice or pay of salary of the length of notice, and the latter is given, the party seeking to contract must pay to the other party the salary of notice at the time of termination of the contract. It is not even of termination to pay salary in lieu of notice. See Abayomi and Assans Grant unrepeated suit number NICN 293/2013. The judgment of which was delivered on the 23rd day of February 2016, where these principles were applied. A rule to make sure that tendering of a letter of resignation by an employee carries with it a right to leave the service automatically without any benefit, subject to the employee paying any of his indebtedness to his employer. Resignation with immediate effect. An employee with three legal effects: the right to leave automatically, the employee's forfeiture of any benefits, and the employee paying any indebtedness to his employer. The justification for having to allow the resigning employee to leave immediately and automatically is a fact that he thereby forfeits any benefit he may be entitled to, as well as the duty to pay off all indebtedness that he may have towards the employer. As such, the corporation benefit as contractual compensation for the immediate and automatic separation of contractual relationship as per the employment in each. Now let's look at the regulation and what does it affect. Nukubiri and Ibekana, that's citation provided. The letter application for voluntary retirement. They said application was the 14th day of July 2000 by the Customs Service and by the provision of section 262 of the Constitution of the Federal Republic of 1999, which is the ground of this nation that stated of the resignation of any person in office established by this constitution shall take effect when the writing signifying the resignation is received by the authority or person to whom it is addressed, or by any person authorized by that authority or person to receive it. That the first respondent was deemed to have resigned on the 14th day of July 2000. In the case of Yusuf versus Governor of the citation provided, aptly cited by the Benin Council for the first to the third respondents, they, at pages 525, 535, paragraph H, in line with the provision of the Constitution cited that the notice of resignation of the president becomes effective and valid the moment it is received by the person or authority to whom addressed. It is not necessary for the person to whom the notice of resignation is addressed to reply that the resignation has been accepted. Ignatius Abuja, paragraph pages 88 to 89, paragraph C. Based on their commenting, as the 17th day of June 2019, CCCBA staff of the organization of the first defendant can no longer be bound by the rule, regulations, and conditions of service of the defendant. Okuta JSC in the case of Wilson and Judicial State and others, citation provided, explain this in its ordinary and proper meaning. Retirement from the public service would imply a withdrawal from that service, which itself will mean that the person is no longer a member of the service. Retirement is paid to be the act of ending your working career with an organization. It can be voluntary or be a forced act of ending service. The only similarity between redundancy and retirement is the fact that such person is no longer service organization. Having regards to the totality of the pleadings and evidence made available, the claimant's defendant was wrongful, unlawful, null and void. As a claimant, as at the 17th day of July, was no longer a staff of the first defendant by virtue of a notice of voluntary retirement, is no longer bound by any decision taken by the first defendant organization. The claimant's relief sought only the court taking aside the dismissal notice dated day of August 2019 issued by the defendant, but served on the claimant on the 15th of August 2019. On the other hand, it fails to prove the need direct and compelling the defendant to reinstate claimant and pay the claimant all his outstanding salaries, benefits, and other settlements that the maintains become due from June 2019 date, including the date of this month, voluntarily recharged from the service of the defendant. With reference to the Public Service Rules, Chapter 304, 2008 edition, Mr. Who resigns will be liable to forfeit all claims to leave, any vacation, leave, or passage privileges granted to the ex-worker. See also section 900 0209046A Public Service Rules 2023 edition. Furthermore, See provision of independent practice commission, condition of service on notice of requirement for government.
Rule
03027 Thor states. A pensionable officer who wishes to resign, a pensionable officer who wishes to retire from service of the commission serving for 10 years or more shall give at least 3 months notice of his or her intention to retire. Section 3 further states in 03021, an officer may resign his appointment by giving 1 month notice of paying 1 month's salary in lieu thereof, and will also be liable to 1. Forfeit all claims to vacation and leave. 2. Return to the commission in full any outstanding indebtedness in respect of agreement, commitment entered with the commission. Counsel argued that the claimant sent in a letter of retirement to take effect from the 4th day of July 2019. The state letter of retirement effect from the same 4th day of July 2019 did not comply with the provisions of Chapter 10, Section 2, paragraphs 10238. Though citation is incorrect, the state retirement was below the 3 months retirement notice as provided by the public service rules. He submitted that the claimant was not wrongfully dismissed in any way as claimed by the claimant, as the claimant absented herself from work without leave. Claimant's counsel stated that he was mindful of the defendant's argument that due process required as a voluntary retirement was not followed by the claimant. He argued, however, that though the defendants are not denying the receipt of the claimant's letter to retire, however, the issue was to the form of the letter. He further argued that in as much as his position may appear cogent, the court is implored to consider the intention of the claimant and the circumstances that surrounded her at the time. As the court to look at Exhibit C18 and not its form. He submitted that equity and does not always and does always look at the form, not the form. The court agreed with the position of the claimant's counsel as the defendant's argument complies with the provision of Section 306 sub 2 of the Constitution of the Federal Republic of Nigeria, alias and the decisions of the appellant in Uokubiri and another cases, Ibekama and others, Supra. In conclusion, the court grants the relief of the claimant's that the claimant's dismissal by the defendant and all acts of taken the 4th day of June 2019 and the defendant amount to immunity in that the dismissal from the service of the first defendant as the claimant as of the time of the dismissal, there was no longer an employment relationship in existence. This means she was no longer a staff of the first defendant organization, thereby not bound by any decision taken by the first defendant. However, it is not entitled to any of the relief sought, and this court cannot grant any. This is the court's decision. The court makes no other cause. Signed, Honorable Justice N. Agbakoba, Judge Kotri, Abuja.
Most grateful, my lord. My lord, the line was breaking at intervals, and I just wanted to be clear as to the conclusive decision of the court in that regard, because the network was breaking at intervals, and I couldn't get clearly, what was stated by your lordship.
Do you want me to read the decision all over again?
No, my lord, just the conclusive part of the decision, my lord.
Okay, in conclusion, the court grants the relief of the claimant to the extent that the claimant's dismissal by the defendant and all action taken after the 4th day of June 2019 by the defendant amounts to a nullity in that the dismissal from the service of the first defendant as the claimant
the time of the
dismissal, there was no longer relationship in existence. This means by staff of the first defendant organization, hereby not bound by any decision taken by the first defendant. However, the claimant is not entitled to any of the relief sought, and this court cannot grant any. This is the court's decision. The court makes no order to cause.
Most grateful, Mr. Lottery.
E.N. Ukukoba, Judge for 3, Abuja.
Most grateful, Your Lordship.
Okay.
My Lord, we are grateful for the judgment, my Lord.
You're welcome.
May we exit the proceedings, sir?
Yes,
As
you can do that.
Yes, my Lord.
What was even happening was as a
Okay.
It was what from his own phone I could at least get what they were saying. What I was saying. I hope I was eligible enough.
Yes, you were eligible enough. Yes.
Because I can hear the voice. Okay, from there. Okay. Even when they were asking that question. Okay. I'm hearing them. Okay. That's when I rose them. But at the end, he said he didn't go there. Yeah, maybe network from the same side. I think 4 of us from and the other lawyer. The other lawyer from his own side. So now you take the laptop and install the Zoom. Yeah, let me see what. So can I get the picture?
Okay. Can accomplish. Hello, hello, hello. Yes, we are done.
other one that is